Appeals is now in session. Please be seated.
Good afternoon. Just a reminder to everybody that the oral arguments are being streamed live. So, and I don't remember right now, if we have any cases that certainly involve any children in them, people arguing, lawyers or pro se's, if you would try to avoid using their names to the extent we can. We try to, the courtroom's open to the public, but we try not to quite put it out there on the internet that much for sensitive things involving children. Call the first case, please.
Olivia May Marcel versus Brad Joseph Marcel.
We'll hear from the appellant. Good afternoon.
Got a frog in my throat, so I'll do the best I can. My name is Roger Bean. I'm an attorney from the Coffee County Bar. I represent the appellant, Mr. Brad Joseph Marcel. I would like to reserve about 3 minutes for rebuttal if that's needed.
That'll be fine. 3 minutes.
This is an appeal from the Chancery Court of Coffee County, Tennessee, in a domestic case. We have appealed 2 issues on behalf of Mr. Marcel. They both relate to the alimony award of alimony in futuro of $1,500 per month. And before I go any further, I need to let you know of a mistake that's in our brief. In the table of contents and the first statement of the issues, it erroneously refers to the alimony as alimony in solido.
That's
it is
an issue
alimony
too.
in futuro, and I think it's correct everywhere else. Your Honor, the first issue is the type of alimony that the trial court awarded. We do not think this is a proper case for an award of alimony in futuro or periodic alimony pursuant to TCA 35-5-121. The second issue is the amount of the alimony, which is $1,500 per month. We would contend that that $1,500 is far greater than any alimony award that should be made in this case. The appellee has raised 2 additional issues in their brief, and the first is whether or not Mr. Marcel had the ability to pay the $1,500. The second is whether or not the court erred in using the appellant's last 4 pay stubs in setting his child support. The facts of this case are really pretty simple. The parties were married for 21 years. They have a 19-year-old son and a 12-year-old daughter. The court split custody of the 12-year-old daughter. Mr. Marcel, my client, has a high school education and he's employed at Nissan. Ms. Marcel worked as a head medical nurse for 15 years during the marriage. She was a certified medical assistant and a certified x-ray technician. She says that she stopped work in 2016 as a result of her medical condition. There was no medical proof whatsoever offered at the trial of this case. Ms. Marcel drew Social Security for some period of time, and that was terminated so that she was no longer drawing that at the time of the trial. As near as I can tell from the record, and I did not try this case, but as near as I can tell from the record, I don't see any efforts that she has made to get a job or to rehabilitate herself. The court found that she's not totally disabled, but did set her wages at minimum wage, which is $1,256 a month. The court set the husband's wages at $1,126.80 per week, or $48.82.80 per month. That is based on the last 4 pay stubs of Mr. Marcel, which the court specifically ordered him to bring and put in evidence after the trial. First, with regard to the alimony in futuro award, alimony, of course, in Tennessee is governed by statute 36-5-121. Section D2 of that statute provides that there is a legislative intent that, with regard to alimony, that the court prefers rehabilitative alimony over and above in futuro alimony. The statute states that a disadvantaged spouse should be rehabilitated if feasible, and it is only where the spouse's rehabilitation is not feasible that the court should consider long-term periodic alimony. The Gonzewski case is a case that's cited in pretty much every domestic case that comes up now, and that pretty much says the same thing, that there's a statutory bias for transitional or rehabilitative alimony. And it's only when the court finds that the economic rehabilitation is not feasible is it proper to avoid long-term or periodic alimony. In this case, there is no finding that Ms. Marcel cannot be rehabilitated. And I think that's probably the most important part of our argument with regard to the alimony. You know, she's got 2 medical certificates. There's no medical proof that she's disabled. She's only
there was certainly proof presented as to her disability, though, right? Her medical problems. She testified about it.
She testified as that, and the court said that while she wouldn't qualify her as an expert, she could testify as to her own health.
Certainly. Was there testimony about, and I'm trying to make sure I've got the case right, the 19-year-old son talking about an incident where he performed CPR on her? Was that?
There was testimony to that effect, yes, sir.
Yeah. That's kind of a serious event, isn't it?
Well, I would say from her standpoint that would be, but that just because of that, I've got a lot of serious medical conditions, but I would probably be capable of being rehabilitated.
And your conditions aren't in the record and discussed either. So.
That's correct. You know, Miss Marcel is only 41 years old, and it's obvious from her background that she's intelligent. She's got the ability to be rehabilitated. There are a lot of things she could do. She said the main problem she had was when she would stand up, blood would pool in her legs, and sometimes she would collapse. A lot of things that she could do that doesn't require her to stand for any extended period of time or not to stand at all. I think there's just no reason in law or in fact that she should receive alimony in futuro. The second issue deals with the amount of the alimony is $1,500 a month. Of course, alimony, there's all these subsections in the alimony statute, but other than those two, the most important thing is the need of the person that's asking for the alimony and the ability to pay of the person that is going to be paying the alimony. I don't think she showed enough to get $1,500 a month. If you look at her expenses, and if you look at some of them which are high, some of them which she won't have to have, she got $165,000 out of Mr. Marcel's 401k, and she got an additional $40,000 from the sale of the house, where he bought the house from her. So she's got plenty of funds to do some of these things. She's got a car debt on there and a house debt on there. She has plenty of funds that could make those lesser or eliminate them altogether. So if you look at the expenses that she has, when I total them up, I come down to that she should have reasonable expenses of about $463. Now that's taking the car off.
You're saying that she has a deficiency of that amount?
Yes.
Okay.
Yes. That's what her expenses are over and above what she makes. And so we contend that the alimony should be limited to the time necessary for her to rehabilitate herself, and that it be limited to the amount that she has shown, which I believe to be about $463. If you look at Mr. Marcel's ability to pay, the court found that his income was $48.82 per month.
Excuse me. You want her to have rehabilitatory alimony?
I don't want her to have any alimony,
Well,
to be honest,
okay.
Your Honor.
You suggested that she might deserve.
If she deserves alimony, it should be in the neighborhood of $450, $460 a month, and it should be limited to a time that would reasonably be required for her to rehabilitate herself.
I thought you said there was no evidence or no finding that she couldn't be rehabilitated. So
There is no finding by the court
Okay.
that she could not be rehabilitated.
So you want this to be rehabilitatory alimony?
Yes, sir.
Okay, understood.
Okay.
Does the trial, I'm sorry, go ahead.
I was going to say rehabilitated to do what, though? Go back in the nursing field?
Well, there wasn't enough proof at the trial for us to really say what that would be. I don't know if it would require a remand or if you can look at the transcript and see, but I mean, everything that I've read says to get alimony in futuro, you have to first show that the person cannot be rehabilitated. They didn't show that, and they're the ones that are asking for the alimony.
I mean, the trial court found that she has serious, let me see here, use it exactly. Court finds that the seriousness of her medical condition substantially limit her employment opportunities.
But that's,
Did she have more of a burden to show than that?
I would think so. I mean, there are all
Well,
kinds of
what is she,
medical conditions.
tell me, what would the burden be? What does she have to show? Does she have to eliminate virtually every job?
No, Your Honor, just to a reasonable extent. But they didn't put on any proof about that. I didn't try the case again, but there was no proof that I recall in the record.
Well, if you put on proof that she can't stand up, can't do those jobs standing.
Well, it's said sometimes when she stands up, blood pools to her legs. That's what it says.
Okay.
And I'm not arguing that she doesn't have some issues.
Right now, I'm trying to figure out who had the burden, though. And if she puts on the proof showing her serious medical conditions, the trial court found serious medical conditions, and she testified what they were, and she testified to the impact it has on her. Does your client have any burden then to show that, well, okay, maybe you can't do the jobs you used to do, but here's some jobs you can do? Who has the burden?
Yeah, I think she's the one that's asking for alimony in futuro. I think that's her burden to show that, and I don't think she showed that she couldn't be rehabilitated.
To do
she showed
what?
That she has problems.
That's my problem. I mean,
Well,
who has
there's
to
all
show it? So you're
think
saying
they
she
do.
has to show that she can't be rehabilitated to any job?
No, I mean, that's an impossible burden, but she has to show within reason that she couldn't be rehabilitated.
Well, did your
She could work
client-
as a receptionist in where she worked when she was a nurse.
Did your client or your client's attorney put on any proof about what job she could do?
My recollection is that there was cross-examination about that with Ms. Marcel, but I cannot honestly sit here and tell you I recall exactly what that is. Okay. Your Honor, is this timer for my total time, or does that get me down to 3 minutes?
This gets you down to 3 minutes.
Okay, all right, I'm not in too bad a shape then. If you look at Mr. Marcel's ability to pay, and you take the amount that the court awarded, or the court said as his income, and you take his expenses, he doesn't have the ability to pay $1,500 a month. This is explored in the brief, and I won't go back through and read that, but he just doesn't have the ability to do that. His expenses are more than his income, or right about the same as his income. So I don't see how he can pay $1,500 a month in alimony, whether it's in futuro or whether it's rehabilitative. He just doesn't have the ability to pay that. I'm at 0, so I will sit down and reserve my time.
You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors.
Afternoon.
Eric Birch of the Coffee County Bar. I represent Olivia Marcel in this appeal. Your Honors, the first thing I want to touch on is Miss Marcel's need and why that prevents her from maintaining gainful employment. Everybody was in agreement that these health concerns were real and they were serious. Mr. Marcel himself stated he had no doubt that his wife suffered from the heart problems as she stated. The party's daughter testified her mother hadn't worked and had been sick for 4 years at that time. Now it's 6. And as Justice Sweeney noted, that the son had to give her CPR and agreed. The son, who had chosen sides with his father, he agreed that her health problems were serious and that they were real. she had to be taken to the hospital when these problems originally started by Mr. Marcel. Mr. Marcel had to be called, take her to the local hospital there in Tullahoma, where she was, over the course of time, diagnosed with a series of heart conditions.
So is your position that she can't work at all?
That is my position, Your Honor.
But the court still imputed some income, not?
The court did impute minimum wage to her, but there wasn't any proof that she had the ability to work a minimum wage job. We haven't raised that issue on appeal because even with the amount of income that the court attributed to her, she still has a need of at least $1,500 per month in alimony. And a little word about the medical proof and the disability. And Mr. Marcel canceled her health insurance right as this divorce was. I don't think he had been served yet, but her health insurance was canceled. She lacked the ability to go see the treatment providers because he canceled her insurance. Mr. Marcel allowed her Social Security to lapse. Mr. Marcel, she's also been diagnosed with several mental problems. He was named the payee on her account. She was not in the marital home. She had vacated the marital home when they had an altercation. She left the marital home and went to live with her parents. He received the notice from the Social Security Administration, and rather than bringing it to her attention, the Social Security simply lapsed. So all she had during the whole pendency of this divorce, she was living off the kindness of her family and her friends and the generosity of those people, and the only income she had was $400 per month, which came from Mr. Marcel. So I think the record is clear that she does have a need, that she hasn't worked in years, and I think that is good enough to get us over the bar where she's not a candidate for rehabilitative alimony. This is a long-term marriage.
Yeah, did she put any proof on as to whether or not, I mean, I understand she testified about her prior work.
Yes.
And ability to stand and all this, but did she put any proof on that she couldn't do other jobs, such as working as a receptionist in a doctor's office, I think they mentioned?
There was no vocational expert that testified. She testified she didn't believe she could work, and had been out of the workforce for years.
I understand she's been out of work.
That was the extent of it.
That kind of begs the question. Yeah. I mean, did she put any proof on saying, look, I obviously can't work as a nurse anymore or as a physician's assistant, or but I can't do these other jobs that would involve more sitting than standing?
I don't think that she specifically touched on that. It's just
did she generally touch on it?
I can't remember what the exact wording was, Your Honor, but it was uncontested that she hadn't worked in years and that she enjoyed her job. It was as a medical assistant rather than a registered nurse. I think the word nurse was being used loosely. But she definitely is economically disadvantaged. Now, the question is that I come to, and where I spent most of my time in my argument section of the brief, was that the court, where we believe the court erred, was in setting his income at the $42.82 per month, just cherry picking those last 4 pay stubs that he received from Nissan, rather than a broader view of what he had made since the beginning of 2019. That's where the proof came in, what the proof of his income was. In 2019, he had an income of $93,000. And in 2020, even though he only worked approximately 9 months of 2020 due to the unprecedented COVID shutdown that, to my knowledge, hasn't occurred at Nissan, something like that hasn't occurred at Nissan before or since. But even considering that, he had made $57,000 through the end of November. The court didn't make any consideration for any overtime, even though he had worked 113.8 hours of overtime even in 2020 and 30 hours of double overtime in 2020. So his income, even if you just focused on 2020, should have been much higher than that for child support. And it kind of goes hand in hand with the argument that he's got the ability to pay if you look at what he had actually made for the previous 21 months that he was actually working since the beginning of 2019.
Why would you use 21 months instead of saying 24?
Well, the reason I did that is because a shutdown like COVID was hopefully a one-time thing. And going through, he says he was laid off for 6 weeks. I think if you look and do the actual math, it's closer to 2 months. And it looked like Nissan was shut down a lot longer than that because he had used up approximately 8 weeks of paid time off that he had banked on hand due to his long tenure at Nissan. And this wasn't in the proof, or it wasn't explicitly stated, but my guess would be that he used all his PTO until he was out, and then he transferred to unemployment. But even the unemployment income wasn't included in his gross pay for child support purposes, which he was receiving right at $300 a week is what he testified to. So I've cited numerous cases that deal with irregular income and situations such as overtime. There's cases that say a court should look at 2 years, 3 years, 4 years. I guess every case is different. The child support guidelines just say a reasonable period of time, whatever that means. But if the court's got evidence of a broader view of what he has traditionally made over the course of, a 2-year period of time, and the court had that available in this case, I think it's error to side on that rather than looking at the actual numbers since the beginning of 2019. So we are asking that his child support be based, his income, that his child support be based on the average of 21 months that he was actually working.
Well, I'm not sure you quite ever answered, though.
Okay.
Yeah, you picked 21 months he was working. Why not the 24 months for 2 years?
Well, it was actually only 23 months, Your Honor,
Well,
because the last paycheck that we have is from November 29th of 2020. Again, the reason why I feel like it's appropriate, I'm arguing that it should be 21 months because he wasn't working due to the COVID stoppage.
But if you say you look at this whole period of time, why do you cut it off there at the
If you
months
go
where you
by
didn't
the
happen
23,
to work?
I'm sorry. If you go by the 23 months instead of 21, his average gross income, just using the payments from Nissan, not including the unemployment benefits, which would also be part of the child support equation, but if you just look at the money that he was paid from Nissan, his gross income is $62,5247, over $6,000 rather than just a little bit over $4,000 due to he has traditionally received overtime. And if you look at 21 months, it's a little over $7,000 as opposed to the $62,52. Either way, I think his child support, if you look at the guidelines, should be increased to base it on his real income. And it kind of shoots their argument in the foot that he doesn't have the ability to pay. And he talks about these income and expenses statement that my client's income and expense statement is unreasonable at $3,420, and then he presents an income and expense statement of over $4,300 per month. You know, and he includes expenses for that aren't there anymore, that are for the party's adult child who's working, and things of that nature. And the court found that those expenses should not be included as far as a deduction. So I believe that's why the court settled on the $1,500 a month figure, even though if my client's not working, all she's gonna have is the $1,500 per month plus the child support, whatever amount the court decides to set his income for child support purposes. So they talk about she could cash out her 401k and use it to buy a house and a car and things of that nature. Well, he could do the same thing. He received just as much money as she did from equity in the home and in his 401k.
Won't the courts require you to deplete your assets before you can qualify for some form of alimony?
I think case law is clear on that point, that the disadvantaged spouse is not required to liquidate his or her assets in order to reduce or eliminate the need for alimony. The 401k is meant to provide for each party's retirement, not to cash it out to meet their day-to-day monthly needs. So in a nutshell, we would submit that the $1,500 per month in futuro should remain undisturbed, and Mr. Marcel's income for child support purposes, we should look for a longer period of time. Rather, I don't know where we got the 4 latest pay stubs, and we were going to average those and set his income. That's what the trial court said, but I think case law is clear. When you have more information available showing fluctuations in income, that is the better tool to use rather than just a short snapshot in time. I'm sure we've all seen situations where someone going through divorce loses a little bit of their motivation to work. I've seen that a few times. In 25 years I've been practicing divorce law. So, thank you, Your Honors. Unless there's any further questions.
I hear none. Thank you. Hear from the appellant in rebuttal.
And with regard to his income, I think Your Honor hit the nail on the head. If you're going to average, you have to average. You can't cherry pick like Mr. Birch did and just pick the times when he was working. It took him 11 months in 2020 to earn that money. So that's what the court should use. Obviously, the trial court thought that because she asked him for those 4 check stubs, and she relied upon those in her ruling. I went back and looked while Mr. Birch was arguing, and what the court said, if I read this correctly, is that Ms. Marcel is not totally disabled, but that her conditions may or will, I don't remember if it was may or will, let's see, will limit her ability to work. And then and at that point she said, we're going to use minimum wage for her. I'm not going to walk through all of Mr. Birch's fact, numbers and figures and everything on Mr. Marcel's income. I think the court has a good grasp of what that is. There's 2 reasons why you shouldn't use the averaging that he proposes. First, this is a setting of an initial child support amount. The case law, as I understand it, and we cited some cases in our brief, state that the only time that you can use a person's ability to earn as opposed to their actual earnings is if you find out that that person is underemployed or unemployed. And obviously, there was never any indication of that in this case, and certainly no finding by the court. And, you know, the guidelines, they give the court the discretion to use whatever reasonable time the court thinks is appropriate. And we're talking about current support here, so there can't be anything any more accurate for current support than Mr. Marcel's current earnings. And that's what the court did in this case, is they used his earnings. We feel, strongly that this was not a proper case for alimony in futuro. Alimony in rehabilitative alimony, maybe. And that's our main thrust in this case, and I would just ask the court's consideration on that point. Thank you.
Thank you. Of course, thanks to counsel for your briefs as well as your arguments here today. Call the next case, please.